Hello friends, how are you? Namaskaram. Today I am going to discuss an important judgment of Honorable Madras High Court, wherein a great decision had been inclined in favor of the accused and the concerned accused had been declared to be discharged from the alleged offence under Prevention of Corruption Act. Friends, as far as Prevention of Corruption Act is concerned, you might claim the plea of discharge, but the key point is that all thing depends upon the way of you avert. All thing depends on the way you draft. Sometime there might be a miscarriage, because if a petition is submitted before the concerned magistrate or a concerned district judge, he might reject the petition. But the key point is that if our pleas are strong, effective as per law, in that scenario we could avail remedy even from Honorable High Court, and if in case there is again a second miscarriage, then from Honorable Supreme Court of India. So we have to understand the basis of discharge. We have to understand the cases wherein there is no role of the innocent accused person, but he had been implicated by the ACB or by CBI on the ground that the concerned CBI or ACB or vigilance is of view that the concerned accused is guilt. So concerning the said offences, the present case inter alia deal with the part of remedy to be inclined in favor of the concerned accused. So everything is important. Just make a comparative analysis of your case and the present case so that you could easily apply the principles of the present case in your case and could avail remedy as per law. Okay now? Friends, on the left side, just put up your case, and on the right side, put up the argument which I am going to avert to you step by step. Point number 1, the alleged offence. I am not concerning under what sections you had booked, but the key point is that if you are not caught red-handed, in that scenario the content is useful to you. But if you are caught red-handed, then there is no need to continue with the present case, because in the present case the concerned accused persons are not caught red-handed. Rather than for the offence of forgery, cheating, misappropriation, criminal misconduct as defined under the PC Act, they had been prosecuted. So in the comparative analysis, at point number 1 we have to narrate the sections. At point number 2 we have to narrate the incidents with motive. I am not concerning what case you are having, but to be noted that in the present case at hand, every accused is having a specific rule. In the present case, the allegation is of cheating, conspiracy, misappropriation of funds, forgery, and criminal misconduct. So the key point is that the concerned accused had been charged with the said offence in the individual capacity, but he submits that the offence has not been committed by me, rather than I had been wrongly prosecuted by the concerned agency. He submits that basically at the inception there was 2 schemes by the concerned government. One is PMAY, that is Pradhan Mantri Awas Yojana, and other is Swachh Bharat Mission, that is called SBM, and both is for the concerned Gramin place. The case of vigilance is that the concerned accused persons had conspired. The inter alia provided funds to the concerned beneficiaries who are not listed. The inter alia provided funds to the concerned beneficiaries who inter alia had not completed the work of construction. And ultimately, the funds concerning with government had been misused and misappropriated and finally embezzled by the concerned accused persons by having hand in glove. At inception, there were only 9 accused, but later on accused number 10, 11, 12 had been robbed in. The role assigned to concerned accused number 10 is that without verifying the fact of construction, he inter alia issued the check and vouchers, resulted in a great loss to the concerned exchequer. In the present case at hand, the concerned vigilance had taken up the matter. After having the proper approval, FIR has been registered, and ultimately the concerned accused person had been charge sheeted. As far as motive of crime is concerned, it is submitted that the concerned BDO issued check without verifying whether toilet or the concerned house is constructed or not. It is a case of concerned vigilance that when the concerned accused number 1 was on leave, on his place he was having the additional duty, means additional charge, but without verifying the fact, he had discharged his duty in the illegal way. By abusing the process, inter alia, a great loss had been caused to the concerned government. What loss had been caused? Means payment to those beneficiaries who had not done the construction. Payment to those beneficiaries who are not actual beneficiaries, and apart from that, there is a money diversion. So with all such illegalities, FIR had been proceeded. To be noted that in the present case at hand, the accused is not caught red-handed. Sometimes there is a possibility that the concerned ACB or Vigilance or CBI might engage you in Section 7 of PC Act as well. Remember that for prosecution under Section 7 of PC Act, there must be demand. If there is no demand, you cannot be prosecuted. There is a recent law point on that subject, that is Dilip Bhai versus State of Gujarat. Judgment is pronounced by Honorable Supreme Court of India, dated 27th of February 2025. The present case is also the glaring example regarding the misuse of process. Judgment name is NG Kamla Ranjan versus State of Tamil Nadu. Judgment is pronounced by Honorable Madras High Court. Judgment is dated 15th of April 2025, bearing petition number 2380/2024. In the present case at hand, the concerned accused had moved under discharge. There might be certain confusions in your mind to move for discharge or to move for question. I want to clarify that the discharge is best remedy. The key point is that in discharge we are having two tiers, the Sessions Court and then the High Court. But in question we are only having single tier, the Honorable High Court. In case remedy is not inclined, then we have to go to Honorable Supreme Court. So it is best remedy to go to Sessions Court for having the proper discharge remedy. He submitted that the concerned BDO is not responsible in the individual capacity because there are several divisions in Panchayat Union Office dealing with the project. The division of engineer, deputy BDO, zonal deputy BDO, Panchayat Union Manager. Apart from that, he emphasized that the said work is inter alia done as a team. In that scenario, it could not be said that the concerned BDO is responsible in isolation. So when every person is having the specific duty, in that scenario, the work discharged by them cannot be a basis of vicarious liability against the accused in the individual capacity. He submitted that the concerned project is the outcome of a special scheme of government. In that scenario, work has been allotted to the concerned accused number 1, who inter alia done the inspection through his ground level team, and on the basis of report, he sanctioned the consent scheme. And after that, when he was on leave, he mounted pressure that amount is to be released, because if the amount is not released, in that scenario, the labor would be affected and the scheme of government could be affected. So, concerning A1 scenario, A1 side, the amount had been released without having any ill intent to misappropriate or to embezzle the same. The key point is that accused submitted that the scheme is for poor. It is admitted fact. Basically, there is a ground level team who inter alia scrutinize who is poor, who is real beneficiaries, and the consent proposal is submitted to concerned Panchayat Union Engineer. After having the scrutiny, the report is given and report is approved by concerned BDO. But the said case is not allotted to him because he was not the regular BDO of the said project. Rather than he was having the additional charge due to medical leave of the concerned accused number 1. And apart from that, whatever process is specified in the protocol is followed by him. Inter alia, there were multiple installments. First installment is to be issued when work is to be started, and then on progress of work. So he submits that there is no ill intention on his part. He submits that there are other beneficiaries, and concerning them the amount has been credited in the account submitted by them. So in that scenario there is no illegality on his part, and apart from that there is a process lapse, and if the concerned ACB or vigilance is not able to find out a real case, in that scenario the accused could not be liable. And ultimately he submits that when the work has been done, it is approved by the ground level team, after that by Panchayat Union Engineer, and on the basis of which the amount has been released, there is no illegality, and court approved all the point and discharged the accused. So the said judgment inter alia enlightened us the 10 principle of law, which is quite beneficial for us. Friends, remember one thing, do not be in a hurry while doing the public function. In multiple sessions I had submitted to you already that if you are in anxiety and doing a work, and if there is some irregularity or illegality, you might be prosecuted. At that time, no official would come to help you. You have to face the consequences. So, better thing is that delegate your work, and on the basis of report, have to work out. And it is a common phrase in India that "Bande raho pagla, kaam karega agla." We have to follow. Number 2 point is that whatever a project is allotted, find out what is your exit role. And the nature of hierarchy is also important. And apart from that, if there are certain subordinates to assist you in the said project, specify them and have the proper reporting in the concerned order sheet maintained at office basis. Point number 3 is that whenever an inquiry had been conducted by the concerned vigilance or concerned CBI or concerned ACB, do not be terrified. Try to answer their case, but not verbally but in writing. Because in India we are having a common phrase, 100 baka aur ek likha. So we have to write each and everything, not verbally but in writing. Fourth point is that whenever a case is concerned with construction work, try to have the proper inspection on regular basis. Because if you are going to rely on reports, if report is fabricated, then you might be in hot water. So do not rely on the report submitted by the concerned subordinate while having the proper signature prior to your submissions. So whenever they are going to submit the report, ask them to verify it again in your presence, so that in case report is fabricated or there might be a case of mismatch of signature, then you could have the benefit. Please note down that whenever you are going on a spot, you should take a photograph of the spot, and apart from that, use the longitude protocol as well. Point number 5 is that if there is subordinate or there might be higher authority and you are in middle, try to communicate with both authority in writing. Do not do any work in verbal mode. If you are going to do things in the verbal mode, you might be in the hot water. Point number 6 is that whenever report is submitted to you, have the proper verification from the concerned agency, and on the basis of concerned submissions, recommendations, proceed further. If there is no recommendation, no proper submissions, then it might cause trouble to you. Point number 7 is that whoever the beneficiary, doesn't matter. But the key point is that whoever is scrutinized by the concerned engineer or by the concerned ground level team to have the benefit, try to maintain the proper record. Have proper PAN card, Aadhaar card before making the payment. And apart from that, try to take the proper indemnity bond in case there is any irregularity, then you could avail the benefit. Point number 8 is that in such cases, the remedy is available on the administrative side. So there is no need to worry. And point number 9 is that whatever the complaint it may be, but if there is any complaint by the beneficiary, up to what extent they are deposing against you. If there is no deposition against you, even there is no prima facie case, then you could avail the benefit. And last but not least, you have to specify to the concerned court that it is not the individual work. It is a team, and whatever function assigned to the concerned team must be specified by you in your petition. And apart from that, you have to specify that you are the concerned head of Pinnacle. So in that scenario, whatever submitted to you by the way of scrutiny is inter alia perused by you, observed by you, and having the proper precaution, you had inter alia recommended to issue of funds or inter alia issued the consent check. Okay, now so on that points, we could create the immunity and could be saved from the false litigations. So this is an important topic. See you in the next video. Till then, Jai Hind, Jai Bharat.